Hey guys, welcome to my legal classes. This is Ganesh Pujari and I am going to start a new series of lectures on chapter 29 of CrPC. You heard me right. It is not a single session. It is going to be series of lectures because chapter 29 of CrPC, which deals with appeals, has as many as 23 sections starting from 372 to 394. Now, if I try to handle them all in one single presentation, I cannot justify. And being the student of law or an advocate who is referring this video, you cannot get satisfactory answer if I try mix everything in one single session. So in this session, I am going to deal with first 5 sections starting from section 372 to 376. 373 deals with appeals from orders, 74 deals with appeals from convictions, and 75 and 376 are dealing with no appeal in certain cases. These are the 5 provisions we are going to learn, and let's get into our first slide. In the first slide, no section, nothing. Let us try understand simple meaning of appeal as well as few other aspects related to appeal. First thing first, what is the dictionary meaning of appeal? Appeal is an application to a higher court for a reversal of the decision of a lower court, or it may be an act of one party to take the case to a superior court and challenge the judgment of the lower court. By making appeal, it becomes the review of the case, or sometime if there is any error in the judgment, that can be reviewed. So that way the appeal can also be treated as a corrective mechanism. Now, why are the appeal made? Appeals are mostly made to fight for the reversal of the judgment or for reduction in the punishment. Now, when can the appeal can be made? Like wherever there is a question of law or whenever there is question of fact is involved, there can be an appeal in those cases. If you want to see the constitutional provisions related to appeal, you have to refer Article 132, 134 and 136, which I am going to touch upon in my next slide. So that's all for the first slide. Let's get into the sections now. The first section of the chapter 29, section 372 says, no appeal unless provided by law. If there is a provision in the law, then only you can make appeal. Otherwise, there is no chance to make appeal. The only exception that we can find is in Indian Constitution, where there is Article 132, 134 and 136 are discussing about appeal, where the Constitution of India makes possible to present an appeal to the Supreme Court against the order of acquittal passed by the High Court. But if you think these articles are easy to implement, no. You need to have significant new things to bring a special petition into existence. It is not that easy to bring a special leave petition. So if you satisfy the requirement, then only there can be an appeal made under these articles. Otherwise, section 372 of CrPC stands good. That is, no appeal unless provided by law. Then comes section 373, which gives an opportunity to appeal against the orders given under section 117 or 121. Now, what is 117? If any person who is being ordered under section 117 to give security for keeping the peace or good behavior, or if any aggrieved person by any order refusing to accept or rejecting a surety under section 121, they can go and appeal in court of session. That opportunity is there with them. However, there are 2 important exceptions. If a session judge has given a judgment or sentence on section 122(2), where reducing the amount of security for release of person in imprisonment, or under section 122(4), that is conditional discharge, those cannot be appealed in front of court of session. That are the 2 important exceptions you need to remember. While section 373 discusses about appeal from orders, section 374 goes little further and discusses about appeal from convictions. Here the conviction is already been completed. In that case, can there be any appeal? There are 4 important provisions, and the first provision deals with person convicted by a high court in its extraordinary original criminal jurisdiction may appeal to the Supreme Court. So here the person got convicted by the High Court and he may appeal to the Supreme Court. That is subsection 1. And subsection 2 says person convicted by a trial in the session judge or an additional session judge or by any other court in which a sentence of imprisonment for more than 7 years, then he may appeal in High Court. So in above all the courts, if the imprisonment is for more than 7 years, then he can appeal in the High Court as per the subsection 2. What if the imprisonment is less than 7 years? In that case, there can be an appeal in front of the Court of Session in 3 different opportunities. First being where a person is convicted on a trial held by a metropolitan magistrate or assistant session judge or magistrate of the first class or of the second class, or sentenced under section 325 which discusses about procedure when magistrate cannot pass sentence sufficient severe, or in respect of whom an order has been made or a sentence has been passed under section 360 which is basically on probation by any magistrate. In all these cases, an appeal can be made in the Court of Session. Then comes subsection 4. Subsection 4 was added via Criminal Law Amendment Act 2018. You need to have a little background for this particular section because there were 3 major amendments came with regards to rape in India, that is Criminal Law Amendment Act 2008, Criminal Law Amendment Act 2013 and the Criminal Law Amendment Act 2018. And all these sections which are related to section 376, and I have named all those sections in detail below also. They are all coming from IPC, and if there is any offense happened under those sections and if there are any opportunity to appeal, in that case those cases should be disposed within a period of 6 months from the date of filing such appeal. So there is a timeline of 6 months for making the appeal as well as disposing the case. That is a very big subsection which is being added in section 374. Then comes section 375 and 376 which are discusses about no appeal in certain cases. That means you cannot have appeal in all the cases. There are certain cases where you cannot make appeal also. What are they? Section 375 says no appeal when accused pleads guilty. Here the accused himself pleads guilty, and if such conviction has happened in High Court, then there is no appeal. Or if it is happened in Court of Session or Metropolitan Magistrate or Magistrate of first class or second class, in that case to the extent of legality of the sentence will be kept in mind, and if that is correct then there is no provision for appeal. Only if there is any legality of sentence which is not correct, then there can be an opportunity to appeal. Otherwise there is no appeal lies as per section 375. Then comes section 376 which says no appeal in petty cases. Now it is very important for us to understand what is a petty case, which changes from court to court. Now there are 4 subsections which are discussing about the same. First, what is a petty case for High Court? If there is any imprisonment not exceeding 6 months or fine not exceeding 1000 rupees or the combination of both. In that case, that is considered as petty case. Or in the case of Court of Session and Metropolitan Magistrate, if the imprisonment is not exceeding 3 months and the fine is not exceeding 200 rupees or the combination of both is considered as petty case. In the case of magistrate of the first class, if the fine is not exceeding 100 rupee, then it is considered as petty case. And under summary case, if a magistrate gives a sentence under the section 260 and the sentence is not exceeding 200 rupees, that is considered as petty case. But one important aspect that you need to remember is if there is any of those punishment which are combined with any other punishment which are not mentioned here, in that case it will not be considered as petty case. So it gives the limitation. To that extent only it is considered as petty case, and if there is any other combination added, then that is not considered as petty case, which gives an opening for appeal. However, there are 3 other combinations which can be made with this punishments and they will not give any opportunity to further appeal. They are that the person convicted is ordered to furnish security to keep the peace, or that a direction for imprisonment in the default of the payment of fine is included in the sentence, or that more than one sentence of fine is passed in the case if the total amount of fine imposed does not exceed the amount hereinbefore specified in respect of the case. If that three happens, then it is okay. But other than that, if there is any combination of punishment is added along with whatever I have discussed under subclause A, B, C, D, then it will not be considered as petty case. That is one important aspect you need to remember. So far so good. Out of 23 sections, we have covered 5 sections in this first video. I am going to make videos on all the other sections also. Please subscribe my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are watching my channel, and thanks again.